Good morning, everyone.
Good morning, Your Honor.
Morning.
Morning. Melissa, are you on the meeting?
Yes, Your Honor, I'm on the meeting.
All right, I'm going to just go through, as I see you on the screen, ask you to respond if you can hear me, and then we'll sort out how we're going to proceed. Mr. Johnson,
Yes, Your Honor, here, ready.
Ms. Runyon,
Yes, Your Honor.
Ms. Laws,
Yes, Your Honor.
Mr. Malky Burgos,
I can hear you, Judge.
Mr. McKelvey,
Morning, Judge.
and the jail is present. Just see if they're hearing us.
Yes, Your Honor, we can hear you.
Very good. I'll just ask you to put the jail microphone on mute for the time being until we're back to you. And then I see someone with the identifier FPDSHER.
That's Scott Sherwood, Your Honor. I'm just signed on just to monitor and make sure all my people got on.
Thank you, Mr. Sherwood. Good morning.
Thank you.
All right. We are conducting this business via virtual courtroom. If your matter's up, I'll ask you to put your microphones on. If your matter's not up, please put yourselves on mute. And let me review the list first, and we'll see what we've got going for today. I've got an application for bail hearing pertaining to David Malasso from Ms. Linehan. I believe Mr. McKelvey's appearing in that. I'll hold it ready. David Ruddy is an extradition,
Okay.
although
Okay.
I understand.
I'm gonna give you our number and I can pull it off and
Mr. Ruddy's matter is going to likely result in a release. The Gwinnett County Sheriff's Office has lifted the detainer.
That's correct, Your Honor.
Okay, Nishita Morton, motion to amend conditions of release. So we'll take that up shortly. I have a detention hearing for David Thomas.
Ready on that, Your Honor.
Okay, and then I have, that appears to be it. There may be something else coming in during the course of today on a Judge Johnson list, E-team list for defendant in jail. I'm waiting to get information about it. It's a psychiatric intervention question. The person is on probation and whether or not he should be released to psychiatric care, but we'll have more information about that, Mr. McKelvey and others as we proceed today. Okay, is sitting in the jail right now David Thomas, or is it somebody else? What's your name, sir?
David Malasso.
Mr. Malasso, thank you. And Mr. Malasso's matter is being handled by Ms. Linehan. Is Ms. Linehan on?
I don't believe so, Judge. I think she's anticipating the 10 o'clock ready hold that we had established via email.
Okay. Mr. Malasso, we're going to get to you in just a few moments when your attorney can join us. I'm going to ask the jail to have you step out, and we'll take the next matter. Thank you. Perhaps we could handle the detention hearing regarding David Thomas if the jail can accommodate us.
Your Honor.
Thank you. All right, sir, are you David Thomas?
Yes.
All right, I'm Judge Delory. We're going to be conducting your detention hearing by way of the virtual courtroom because of the current health crisis. Your attorney is present on the line, I believe.
Yes, Your Honor. Your Honor, may I address you? I have spoken to Mr. Thomas this morning by phone. He's indicated to me that he's hired private counsel, that he would like to represent him during his detention hearing, Jill Cohen. I indicated to him that I would make Your Honor aware of that. I am ready to proceed if Your Honor declines that request. He has had one 5-day continuance already for that. However, he is not asking for a lot of time. He understands that he's already had that initial request granted.
All right, I'm inclined to grant the defendant's request for his private counsel, of course. Mr. Malky Burgos, obviously defendant to be held pending further proceedings so his private counsel can be retained. Are you in agreement with that?
I don't have an objection, Your Honor.
All right, very well. Mr. Thomas, is that correct? You'd like time to hire your private counsel?
Yes, I hired her. She was supposed to call this morning. I hired her though. I gave her money and signed contracts with yesterday.
Okay, we'll return you to the pod, and if she checks in with me today while we're conducting virtual court, we'll bring you back in and I'll hear the case. If we have to, we'll schedule it for Monday morning.
All right, thank you.
Okay, thank you.
Thank
So
you, Judge.
we'll hold it ready, counselors. Mr. Johnson, you're excused. Thank you. And we'll
Judge.
list it for Monday otherwise.
Judge, I just had, I know that, just wanted to put on the record that I gave Mr. Johnson the discovery. I'm just hoping that he can email that to Ms. Cohen. That way she has it and can prepare for the hearing.
Mr. Johnson, I'm sure you'll be helpful.
I will, Judge. I will do anything to assist her.
Very well.
Thank you.
All right, well, let's put a control date on for Monday, March 23rd. And if she rings in today, Mr. Malky-Burgos, I'll check in with you and see if we can conduct it today.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
All right. Perhaps we could take up the matter of State versus David Ruddy. Sheriffs, if you could, I'm sorry, Corrections Department, if you could, see if Mr. Ruddy can be brought in.
Your Honor, I was just advised that Ruddy was canceled because Georgia's not picking him up.
All right, well, then we just need to do some kind of release then. We'll take care of this on our end. Melissa, just draft a all-purpose order. I have one here in court with Jamie, very good. All-purpose order. We'll attach Gwinnett County Sheriff's Office communication to it. He'll be released on, well, as the detainer has been withdrawn, so, but I'll sign a recognizance to the extent that it's necessary. Do we know if there were any underlying Atlantic County charges, shoplifting or anything like that?
I'll
Not
check.
that I believe, Your Honor.
There were none, Ms. Laws?
No, Your Honor.
All right, thank you. Okay, well then we'll just order him released for the benefit of the record regarding the alleged fugitive David Ruddy on extradition from Gwinnett County in the state of Georgia. The detainer has been lifted. He may be released forthwith. I've signed the order. Thank you. All right, Ms. Runyon, do you have something?
Yes, Your Honor. I'm ready with Nashida Morton. I have her on speakerphone on my end.
Great, let me get that paperwork out. Okay, let's call the matter of the state of New Jersey versus Nashida Morton on numerous case file numbers. I'll recite the earliest indictment 07-12-2748 on a notice of motion to amend conditions of release. May I have appearances from the state, please?
Deidre Laws on behalf of the state.
Heather Ann Sennigan on behalf of Ms. Morton, who is present via speakerphone.
Thank you. Ms. Morton, can you hear us okay? I heard a yes.
Okay, I'm not quite sure where my microphone is here, so.
Okay. Just assure yourself, Ms. Runyon, that she's participating, and if there's anything she needs repeated, just let me know.
Yes, Your Honor.
All right, I'll hear you for the defense.
So we filed this, it was my actually mistake. I guess it should have been a different form of motion. I'm not sure. We're really seeking to do is modify the conditions of her HEADS program that she's on. When she was placed on it, the judge allowed her only to travel to take her children to school and to go to work. As far as anything else, doing laundry, grocery shopping, or anything, the judge had instructed that she should get other family members or friends to help her do that. Up till now, that hasn't been, a big issue, but due to the recent pandemic, understandably, her family member friends don't want to go out if they don't have to. And then even if they did go to the grocery store, many of the stores now have limits, so they're not able to buy for themselves. And then also for my client, who is a single mom with 5 children, so obviously she needs a lot of supplies. So we were asking just to be able, for her to be able to once, maybe twice a week, have a time to go to the grocery store, get what she needs there, and time to go to the laundromat and do laundry for her family. She's expressed to me neither of those facilities are very far from where she lives. She doesn't need to go, a long distance, and would only require perhaps a couple hours in order to do those tasks. Like I said, once or twice a week. The only other change that she also needed, I believe she needs to go to Atlantic City. I have to check with her how often. I don't know if it's once a month, but she does need to apply for her benefits. She was unable to go last month, so she's missing out on this month's benefits, but she does need to go and apply, I believe, for SNAP and any other programs that she's in. So that was basically all that we were asking to modify.
Thank you very much. State?
The state's fine with it, Your Honor.
Okay. Jamie, what is Ms. Morton's next court appearance?
Sorry, I had that up and then I took it off. Give me
Okay.
1 moment. I'm sorry, Your Honor.
Take your time.
Your Honor, she has a CC, a PI, and a VP and scheduled for Judge Taylor on May 1st.
Okay. All right, I'll leave the May 1st date in for all matters. Obviously, we'll have to reassess dates if there's a problem. I reviewed this matter with Judge Taylor and her initial thinking as to why heads was necessary. And her view at the time was because the defendant had not submitted to the court and had been a fugitive for some time, although it would appear that she was always in the jurisdiction, just not coming into contact with law enforcement to be returned. At this juncture, she appears to be compliant with the court's needs of presenting herself to deal with these charges. They're not overly serious. There are probationary offers, at least initially, on the table, and her record shows no violence. So for those reasons, I'm going to remove electronic monitoring in its entirety. I'll place her on a recognizance bail, fee waived, subject to law-abiding behavior, no contact with any victim, and that she report telephonically to probation until instructed otherwise, and that she report to court on her next scheduled appointment, which is May 1st. I'll sign such an order. The application's granted. I'll inform the jail. Now, of course, she should not be cutting the bracelet off, Ms. Runyon.
Yes, Your Honor.
She should make arrangements with the jail. They may just deactivate it and leave it on her until there's a way they can take it off. Probably no need for her to go physically to jail, but I'll let them work that out together.
Okay, Your Honor. I'll instruct her to call and see what they want her to do. I know she was supposed to go in on Sunday for her next appointment with them, but I will certainly make sure.
Yeah, they may want her to do that, and that's fine, or they may give her other instructions on how to achieve removal. Okay, I've signed the order. It'll get over to the jail today. Ms. Morton, if you would advise Ms. Morton after we're off, Ms. Runyon, as to how to handle herself, and we'll see her hopefully on May 1st if the court's back to normal.
Yes, Your Honor. Thank you.
Thank you.
Thank you,
This
Your Honor. That
concludes my
concludes my
honor.
business.
This
Okay,
concludes
thanks.
my matters as well, Your Honor.
Thanks, ladies.
Thank you.
Thank you.
So for the benefit of the record, the motion is granted and modified to remove heads and place in a ROR with conditions. That concludes the matter. All right, I see we have Mr. Malasso joining us again. Can you hear us okay, Mr. Malasso?
Yes, sir.
Okay.
Yes, we can, Your Honor.
All right, again, we'll mute your microphone until the appropriate time. We'll turn it back on so we reduce background noise. I see Ms. Linehan is signed in. I see Mr. McKelvey is signed in.
I'm here, Judge.
Okay.
I'm sorry, sir.
Take your time, Ms. Linehan. Thank you.
Judge, can you hear me now?
I certainly can, and I can see you. Thank you, Ms. Linehan.
I'm sorry, I had opened an email really quickly. If I could just step away to get it, and then I'm ready to proceed. Thank you.
Please take your time.
I've returned, Your Honor. Thank you for your courtesy.
Oh, not at all. Thank you. All right, let's turn now to the matter of the State of New Jersey versus David Malasso on the defendant's application for an emergent motion to set bond or alternatively to stay removal to Virginia, as well as complaint summons 0108S2020-000089. And that would appear to be it. May I have an appearance from the state, please?
Good morning, Your Honor. Rick McKelvey for the state.
And from the defense?
Mary Lenahan on behalf of Mr. Malasso.
We were last before the court when Mr. Malasso had indicated that he was seeking to resist extradition. And I set the matter down for further proceedings and the securing of governor's warrants and the court's indication to consider release depending on what was presented. Since that time, I've received defense applications on the face of an assertion by law enforcement and the executive branch that Mr. Malasso was subject to removal under the Interstate Compact and required no further proceedings. And I was also made aware of an underlying local charge of shoplifting in the 4th degree and DP paraphernalia, which was also perhaps the cascading event that resulted in his being apprehended on the underlying extradition matter. So that's the procedural background. Ms. Linehan's been good enough to do some initial briefing and research on the matter. Ms. Linehan, I'll hear you.
Your Honor, on behalf of Mr. Malasso, he is here under the Interstate Compact. He was arrested in the Commonwealth of Virginia and ultimately had his probation transferred here. He has no ties to the Commonwealth of Virginia. He was being supervised by probation officer Erica Thurn. The basis of the violation in Virginia is that he picked up the new charges. That was stated on the paperwork that my counterpart in Virginia provided to me. At this point, Your Honor, he's got an open charge. We'd like to resolve that before he's sent to the Commonwealth. Obviously, you understand if he's given a term of incarceration and a charge here is left open, that's going to result in him serving, I don't know, potentially extra years because he's got a charge open here. We do have an agreement on being able to resolve that. More importantly, when I interviewed my client yesterday by phone, I learned of his health issues, and it does appear that Atlantic County is ahead of the curve in how it treats people with addictions. He is being weaned off of a course of methadone. He has serious health conditions, cirrhosis of the liver, as well as hepatitis C, he represented to me. And the concern is if he is taken off the methadone for the transport, the level of I don't know how to say it other than with a street term. If he's dope sick, Judge, it's going to cause his health to cascade further downhill. So researching the statutes, the court can set bond on this fugitive warrant, and I've already made contact with this former attorney in Virginia who is part of the Virginia Defenders Program, but they're monitored by state. That attorney did verify to me that they do not have methadone or treatment in the county jail in any way, shape, or form. So again, we seem to be ahead of the curve on that. So this is a medical issue. If the court were to grant bond on the fugitive warrant and release him on his own recognizance on the shoplifting, Judge, according to the statute, you could bond would comprise pretrial release conditions. So you have the authority to do that. If the court declines to set bond on the fugitive warrant, Judge, then I'd ask that we simply grant a stay until such time that we can resolve the case. And I'll check in with the medical staff and report back to the court on when it would be safe for him to make this transfer. That's my application, Judge. I didn't brief it. I put it out in a certification because it got taken off the list and I was working all day to get it back on again. I have verified all this information with the attorney in Virginia, David Walls. He did provide me with the documents, the capias, the arrest warrant by the judge. And I explained to Ms. Wan that the judge who signed that basically gives instructions to magistrates who are the first level in Virginia that see defendants when they're arrested. The judge did not indicate no bond. He didn't make it a body warrant. So I think that supports our argument that putting a bond on him would be appropriate on the fugitive warrant. But in the alternative, I'm asking for a brief stay so I can consult with medical and we can come up with a plan that's humane and takes my client's health into consideration. I have nothing further.
Before I hear from Mr. McKelvey, let me ask you this, Ms. Linehan. If the underlying Atlantic County charges were resolved today by way of I would assume a plea, because that would probably be, I'm not going to be conducting a bench trial on,
Yes, sir.
on the matter. But if it was resolved by way of a plea to either as charged, waiving proceedings on the complaint, which I understand under the rule you could plead to a fourth, or perhaps the state would reduce the
If I
shoplifting
may,
to a DP. Yeah.
the judge did convey an offer of a disorderly person's credit for time served simultaneous sentencing. So.
Okay. All right. Let me hear from Mr. McKelvey.
Thank you, Judge. In getting caught up on this situation, it does seem that our state participates in an interstate compact known as the Interstate Commission for Adult Offender Supervision, and that's what has enabled the defendant to be supervised in Atlantic County on his Virginia probation. As part of that, the defendant agreed to extradition at the time of seeking the transfer. And so that's why we didn't have a typical extradition hearing in this case. What I additionally think is that there's not much discretion in this court to keep him here. The extradition has been ordered. The Virginia authorities are on their way, I'm told. And so I don't know what sort of discretion lies in the courts with this court at this time. But I do agree with Ms. Linehan that, and as Your Honor suggested, that this matter, the Egg Harbor Township matter, could be resolved here and now to a fines-only DP.
Okay. With respect to my discretion, I do want to look into it a little bit more to understand. I understand what the request is. And let me just get to the upshot, though. If he enters an original plea to an amended charge of DP, shoplifting, or whatever, allocutes, receives a sentence of fines and penalties simultaneously, and then I were to place a money bond on him, he's likely not able to make that, I would think, and that he would await Virginia authorities who would come and pick him up. Is that an outcome that would be salutary in your view, Ms. Linehan?
I think it reaches the goal of allowing him to continue to work with the medical staff who are closely monitoring the situation, but it doesn't set it out. It doesn't string it out too far, Judge. So again, I haven't had the chance to verify any of this with the medical staff, but my client has no reason to misrepresent, his methadone treatment and the treatment he's getting at the jail.
Well, look, I'm accepting everybody at their word for purposes of today's proceedings and always. I mean, I'm sure officers of the court are going to give me the best information available. This is, of course, a very quickly evolving situation. Anecdotally and unrelated to Mr. Milazzo, just a few moments ago, I had a Sheriff's Department from Georgia indicate that they were changing the nature of their extradition needs, and essentially I've released the person who was being held from Georgia. So that wasn't the case last night when I was prepared to do an extradition hearing this morning. I think at least placing a money bond on him that keeps him in the jail and then keeps him in whatever treatment is available. If Virginia changes its mind in the next 48 hours, then we'll be back dealing with this again. If they don't change their mind and they show up, I don't know that I'm in a position to order anybody to resist what appears to be lawful authority to pick up Mr. Milazzo in alleged violation. So if everybody is prepared to proceed, we can move along those lines. If you need a few moments to consult privately with your client, I'll ask everybody to sign off and sign back on, Ms. Linehan, so you can accomplish that.
If I could just check in with him, Your Honor. Thank you. And Judge, your authority on the extradition proceedings under the new Criminal Justice Reform Rule 326 Tac 1, it's paragraph D, indicating you can set bond, and 26 Tac 2 A has similar language. So I just wanted to, obviously your clerk probably had already pulled that.
Yep.
And I did check the interstate compact. There are a number of states who are not retaking prisoners at this time, people they want back. Virginia is not one of them as of when I checked this last night. So I do need to offer that information to the court. Virginia is still retaking people under the compact. If I could speak with my client, I would be grateful. Thank you.
Okay. What I'll ask is other than Mr. Sherwood, if Mr. Malky-Burgos can log off, and anybody else who is not court staff. I'm going to leave court staff on, Ms. Linehan, obviously subject to them maintaining confidentiality.
Of course, thank you.
All right, I'll log off. Attorneys unrelated to the matter, please log off, and court staff will please stay on and rejoin the meeting. Ms. Linehan, just call my clerk, let us know when you're done, and then we can all come back on.
Thank you, sir.
Thank you.